Morning, Mr. Rice. Why don't we get started? This is a press conference that I have before legislative meetings. And tomorrow, January 9th, the council will have its first legislative meeting of calendar year 2024. Before I talk about that, I want to talk about a couple other issues. Um, the I said a couple, let's see what they are. The first is that I got a report with regard to what's happening with appropriations up on Capitol Hill. That's of concern to us, not so much because of the budget itself, because as you know, we have budget autonomy. And the council adopted its budget on time last year. It became law last year. But the Congress persists nonetheless in moving an appropriation bill. And then the House side, there's something like 20 riders. On the Senate side, I believe they're just 2. The latest information that we have from Congress is, and this is actually from a public statement that was issued, that there is an agreement apparently between the House and the Senate moving forward the appropriation bills. The Democrats have made clear that they do not want to see riders added to these appropriation bills. That's of interest to me, and I believe the district, all of the district, because while we don't want any of the riders on the House side were more numerous and much more damaging. One of those riders would prevent any kind of photo enforcement, including, for example, red light running and speeding. And if that was rider was to be adopted, then it actually would create a significant a hole in the council's budget and financial plan. I believe over the financial plan, something like $1 billion. And not only is it objectionable that Congress thinks that they could legislate on these matters, but I believe photo enforcement is at this point commonplace in a majority of the states. A rider that probably will remain, but that's not to say that it's agreeable in any way, is the cannabis rider that has persisted on the appropriation bills for now close to a decade, and that has significant public safety implications. Last week or 2 weeks ago, I sent a letter together with Mayor Bowser and Attorney General Brian Schwab, a letter to the Senate stressing that the cannabis rider is injurious to public safety in the district. We don't want to see any of the riders, but that rider needs to be taken off of the Senate appropriation bill. We also sent a letter to the House. I'm looking to see if I have a copy of it. Again, signed by the 3 of us that objected to all of the riders and asked that the House not go forward with the appropriation bill with those riders on it. If members of the press want copies of these letters, please reach out to Lindsay Walton on my staff. Tomorrow in the meeting, the council will be considering the budget schedule, the hearing schedule for performance oversight. I don't believe we will have the budget schedule in front of us, but we will have in front of us the resolution that we adopt every year that sets forth not only the date for the mayor's submission of the budget, but the all the detail that we want included with the submission. That budget resolution will be adopted by the council. I say that as if I know it will happen, but I'm sure that the council will be voting for it. The schedule is not actually adopted by the council, but it's reviewed by the council. And as I said, those both will be available tomorrow after the meeting. We have a committee of the whole meeting to start tomorrow, so that will be at 11. And because this is a regular meeting, legislative meeting, there'll be a legislative breakfast beforehand where members will be discussing the measures on the agendas. The committee of the whole includes 3 measures for markup, sentencing commission appointment, ombudsperson for children appointment, and officially naming the new high school in Ward 3, the MacArthur High School. There are also measures coming out of other committees. Strengthening Traffic Enforcement Education and Responsibility Amendment Act, being reported out of the Committee on Transportation and the Environment. Uniform Commercial Code, Housing Subsidy Contract Stabilization, and Litter Control Amendment Act, those three coming out of the Committee on Public Works and Operations. Those are being agendized, as we say, not marked up in the Committee of the Whole. The legislative meeting, some of the highlights from that on final reading will be the Proactive Inspection Program Act, which is setting forth in the law a requirement and a program for proactive inspections for rental housing by the Department of Buildings. As I recall, the bill has two tiers, meaning that buildings will be classified as either in tier 1 or tier 2. One of those tiers will be buildings that will be proactively inspected more frequently, which I believe is once every 2 years. And the other tier of the buildings will be proactively inspected every 6 years. This is, we think of most housing court enforcement as being really reactive. There's a complaint, the inspectors come out and they inspect. This is proactive. Not every unit gets inspected, but a percentage of the units in a building, the percentage is higher if the building is smaller. Think about it. If you've got a building of 4 units and maybe it's 2 units, that's 50%. If you have a building of 200 units, if I remember correctly, it's somewhere around 25, 30% of the units will be proactively inspected. And from that, the inspectors will get a sense of the condition of the property and whether in fact they need to inspect more units. That depends upon the types of violations they find, how serious the violations are. I believe there's a provision for, I think it's called Class 1 violations, where if a threshold of Class 1 violations is found, then more units will be inspected. All of this is meant to try to improve the conditions of rental housing and not rely on a complaint-based system. So that bill's up for final reading. The School Improvement Amendment Act is also up for final reading, and that gives the Office of the State Superintendent of Education the authority to work directly with the lowest performing schools in the city, whether charter or DCPS, to work with them in terms of coaching and financial management, curriculum, to improve the educational outcomes in those schools. It's just further resources for the lowest performing schools to try to provide a better education. Typically, these schools have high rates of at-risk students, which is sort of the same as saying of students who live in poverty. And so from a perspective of equity, this is furthering our efforts at improving equity in public education. Because I might get a question on this, the SNAP litigation authorization resolution is remaining on the agenda, not because I expect at this point that we will be going into court, but just ensure that our general counsel has that ability should the situation change. I do want to take this occasion to thank the mayor for changing the position of her agency director and going forward with implementing the enhanced benefits for under the SNAP program, which is what used to be thought of as food stamps. We know that there's a high correlation between nutrition and, for example, educational performance by kids. SNAP is important to seniors and low-income families. And the council had budgeted last year that if the revenues had grew sufficiently, which they did, that these enhanced benefits would be in place for 3/4 of this fiscal year. That is from January 1st until October 1st. So I appreciate the mayor going forward with this. And I would say that I would characterize it staying on the agenda simply as a protective measure. There are a number of emergency bills that are on the agenda. I'm kind of glancing through that to see if any of them particularly stick out, and I don't think they do. So although I will note, Councilmember Allen is moving a medical cannabis program enforcement emergency, which is meant to clarify the enforcement process for any establishments that are selling cannabis illegally. This has become an increasing problem in some commercial corridors, and this is meant to improve enforcement. I think with that, I'll open it up for questions, if there are any. Yes, Mr. Collins.
So Mayor Bowser last week, as it relates to the SNAP litigation, she mentioned her attempt to explore the reprogramming request,
To what?
to explore a reprogramming request. To what degree is that true from what you can, from your understanding?
Well, I'm not quite sure what she's thinking. I know that she has tried some reprogramming in recent months involving the Department of Human Services, other programs, not SNAP, and the council did not agree. It was a shift in priorities. And of course, I was not at the mayor's press conference. She hasn't talked to me about this. Maybe that is to deal with some other spending issues that she sees in the department.
What would be the process?
Well, if she wants to reprogram, if the amount's over $500,000, it has to be submitted to the council for approval. And of course, the reprogramming is taking from one line and putting it into another line. And sometimes what's objectionable to the council is the line from which it's being taken. So for example, last fall, when she proposed to take from emergency rental assistance, the council did not agree and rejected that reprogramming.
So it's a formal process.
Yes, it's a formal, it requires approval of the council. I believe that approval typically is passive, but as I noted just a month ago, the council actively disapproved a reprogramming request.
But as far as SNAP, and forgive me, I just want to make sure nothing came from her desk to the council as far as reprogramming.
Correct.
SNAP.
We have not gotten a reprogramming regarding SNAP.
Okay.
And I would not expect one at this point. Mr. Rice, you have a question?
Downtown, the future of the Capital One Arena, so forth, the mayor's going to have a press conference at 11:30 to announce a task force. Your general thoughts about what should be happening are, and do you know anything about the task force that you can maybe tell us, any membership, and are you planning to attend?
I am not planning on attending. This was just scheduled and I actually have a meeting or a hearing at that time, and maybe even both. And I have not been briefed with regard to the task force. I will say that as you know, as everybody knows, the mayor introduced legislation in mid-December, which every council member co-sponsored, to provide funding for Monumental Sports to upgrade the arena downtown on the condition that they stay. It's my view that until the Virginia deal is done, signed, sealed, delivered, that we should stand behind that offer. And as far as I know, that is what we're going to do. So if Monumental Sports wants to change its mind, or if Monumental Sports has to change its mind, either way, we're here for them.
Oh, go ahead.
Sure. I have a question in regards to, I have it here, the Initiative Amendment Act. So I'm just trying to get an understanding. I know the hearing is during the latter part of the month, but what was the rationale behind that? I just want to hear it straight from you.
I'm trying to remember. I introduced the bill. I'm trying to remember what it does.
So it's about appropriations and ballot measures.
Yes, it has to do with the fact that the value in determining whether there's a fiscal impact is before it's decided by the Board of Elections that there's no fiscal impact. And that's not the practice that they took with the most recent initiative that I know of. The council is very clear in its process. We legislate, obviously, and that initiative is a legislative process. The council is very clear that we identify what a fiscal impact is. And if there's a fiscal impact, then we know that by definition, it has an impact on the budget and the financial plan. The law regarding initiatives has been quite clear for decades, 4 decades maybe, that initiatives are not appropriate if they have an financial impact. The Board of Elections took a twisted view of that and said, well, we'll look at the fiscal impact after it's put on the ballot. And that's just not appropriate. So this bill fixes that.
What would you say to those who, and this is not from me, but from people who I've spoken with, who are a bit skeptical around that line of reasoning, given what the ballot measure was attempting to do in terms of opening primaries to non-party voters, such?
Well, you'll note that my answer didn't speak to the issue of whatever that initiative is, because that's not the point. The point is that we can't have an initiative process that seeks to legislate where it would have a financial impact. And to say that, I mean, and the interpretation that the board applied was new and different from the interpretation that has been applied for the past 3 decades. So if a measure has a fiscal impact, that should be identified. The council changed it. Part of the reason why this came up was because the council changed the law several years ago to require that the Board of Elections get a fiscal impact statement or analysis from the chief financial officer. That did not used to be the case. So in the past, it was conjecture whether there was a cost to an initiative, and the board would determine based on the arguments whether there was a cost. Well, now there's a fiscal impact analysis by the chief financial officer. And the board has essentially said that that's not relevant.
Do you have a position on the initiative on the open primary and ranked choice voting?
I don't support it.
Both provisions.
Correct.
Thank you.
Further questions?
Do you want to comment on the status of your crime package that you introduced recently? What is it?
Well, I've not talked to Councilmember Pinto. I just introduced it right before Christmas. I've not talked to her about scheduling for it. I'll emphasize a point that was made in the introductory memo that accompanied it, that many of the provisions, well, let me start with this. 2 of the provisions, and it came from a task force recommendations that have been a matter of public record for about a year, but nobody's done anything about them. So this bill would put those into law. If I remember correctly, most of the provisions could be implemented without legislation, but the mayor keeps saying that the council needs to legislate, and the provisions have not been implemented, so the bill would implement them. Yeah, I didn't look at the bill before I came in here, but if I remember correctly, one of the provisions which came from the task force recommendations was more emphasis on focused deterrence as a crime fighting strategy, which has been shown to be effective in city after city where it's been applied. And the idea behind that is that a lot of crime and violent crime is committed by repeat offenders. If you focus on these known perpetrators, that's the focused deterrence. And initially, the focus is to sort of turn them around, to deter them. But if not, to get them arrested and locked up immediately, then that will have an immediate and significant impact in reducing crime. There were 5 or 6 provisions, and I'm blanking on all of them. One of them was does require legislative action, and that is to amend the state Medicaid plan to access federal dollars that have only recently become available for victim assistance. And that has, not only is that important in the justice system, but also because some crime is retaliatory, to the extent that there can be assistance to victims and their families, that could have a reductive effect on crime. Another provision is, which the mayor could do, but the bill establishes a specific category of blight, criminal blight of properties, because there's a known association, this is research across the country, that vacant and blighted properties can contribute to criminal activity. So the legislation specifies additional authorities that the mayor would have to go in and cease or remediate that blight. So that would have a reductive effect on criminal activity. Another provision, which does require legislation, is frequent reporting. I think it's twice a year with regard to, if I remember correctly, it's repeat offender arrests and dispositions, so that there's more public understanding of what actually is happening in the system. You know, the public just is not clear. And when I say the public, that includes the council, that includes researchers, everybody. It's like a black box. Folks get arrested, and then what happens in an aggregate level is just not clear. And this is meant to improve data reporting. So that you can see just how many repeat offenders were picked up and released. Data like that. I'm leaving out a couple of provisions. But I think I hope that gives you a sense.
I have another question. The Tax Revision Commission issued some draft recommendations. Have you looked at them, and do you have any thoughts if you have looked?
I've not looked at them. I was briefed a couple of months ago on where they might be going. So that's what I know at this point. But we gave broad discretion to the commission to look at the tax code overall with an idea toward modernizing it. I know we say that about a lot of legislation, but tax policy changes across the country. What are they doing in other states? And are there some new initiatives that we ought to be applying here? One example of that is taxing digital products. Maryland adopted that a couple of years ago. I think it's tied up in the courts. But that's an example of new approaches toward taxation. The goal of taxation, in my view, should be equitable to the extent possible. So folks with more means, and when I say folks, I'm talking about individuals, but businesses as well. Folks with more means would pay a higher percentage than folks with little means. That's equitable. That it be broad-based. And that's broad-based both in taxing sources. So we're fortunate compared to other cities and even states, I would say, in that we have the ability to do a sales tax, a property tax, or a personal property tax, an income tax, a franchise tax. That's broad-based. And then, for example, with sales tax, which when first adopted in this country was on goods, we're much more of a service economy in this country. So the tax base needs to broaden in that sense as well. So the commission is to look at equitability as well as broadening the base, as well as competitiveness. Economic activity generates tax income. So we want to be competitive in that sense and not have folks choose not to do business in the district because it's so much more expensive. I'm speaking in general terms, but these are the philosophical concepts that the commission should be looking at. Any follow-up there?
Yes, thank you.
Yes. Sam. Lindsay, I'm going to ask you if you have got any questions. Well, not you, but you're,
I just wanted some clarity. So as far as the tax code revision, is that going to be discussed in the Business and Economic Development Committee before the Committee of the Whole? Or is that something for?
well, the recommendations haven't come to us, and I'm not sure when they are, but the practice we followed last time was that the Committee of the Whole held a hearing on it, and then it was, their recommendations were adopted as part of the budget. Now, I don't think that latter part will happen this year. I think that my sense is that the recommendations will be so complex that we won't be able to factor that in this year's budget, which we receive in 2 months.
So sort of a tangential but related question. The recommendations or the version that came out most recently didn't really touch on the whole WMATA situation, but with the proposed service line cuts, there are parents and advocates east of the river saying that that could immensely affect students who are traveling across town to go to school. And I just wanted to get your take on that, as someone who frequents a lot of
Sure. So
education.
I'm going to answer that in the context of WMATA, not the Tax Revision Commission. Completely different in my view. Um, the district government has been actively involved with our regional counterparts in discussing how to solve the WMATA problem. Councilmember Allen has chaired the Transportation Committee with oversight over WMATA and myself. With the city administrator, our representatives on the WMATA board, the chief financial officer have been meeting, and we've been meeting as well with regional counterparts. I think I can say with certainty that it's the district's position that we do not want to see the service cuts that the general manager proposed. And we also don't want to see the significant diversion of capital dollars to operating. That's our position going into this, and I'm hopeful that we'll be successful in ensuring that there aren't the service cuts or the capital diversion. I'll say a little bit more. The WMATA estimated last year that they would have a funding shortfall for this coming year. That's the fiscal year that begins July 1st for them, a shortfall of $750 million, and that would, on an annual basis, grow to $1 billion. The region has to solve for this. The goal of a public transit system, this is my view, I'm sure it's Councilmember Allen's view, the goal of the transit system is to provide transit to the public. So service cuts sort of works against that. And while there might be some adjustments, I would not say that that should be the solution. My view as well is that the district government should be asking for a greater contribution from the federal government. When the compact was established in the 1960s, it was a compact between Maryland, Virginia, and the district. Within the last decade, the federal government was given 2 seats on the WMATA board. I think they should pay for them. The federal government, if I remember correctly, close to half of its workers use WMATA, and federal workers comprise almost 1/5 of the total ridership. So it's important to the federal government. About half of their workers use it. And it's important to the system. About a fifth of the system depends on federal ridership. The federal government has to contribute more. And I'm not clear why the region has not been asking for more. I will add this. The general manager's proposal in December had to be a worst case scenario because the rules that WMATA follows are that they can adopt a budget that is better than, but not worse than what the general manager puts out. To illustrate what I mean, if WMATA wants to raise its fares, the general manager needs to put out, let's say, 20% fare increase because they can't adopt a budget. If he puts out a proposal of 5%, they can't increase that. But if he puts out a proposal of 20%, they could adopt something less as an increase. So it has to be a worst case scenario. Any follow?
Yes, one follow-up. So you mentioned Fed contribution. What's the discussion around your regional counterparts, their portion of the contribution?
I can't say it's clear at this point. Governor Moore of Maryland put 150,000 into his budget proposal, which in my view is not enough. I really don't know what Virginia did. I don't know if Governor Youngkin put anything in his proposed budget. I'm optimistic that we'll see the 3 states come up with a significant amount of money. I just don't know how much will be new money as opposed to aspects of the general manager's proposal. Lindsay?
U.S. Attorney sent counsel a letter highlighting concerns about Joel Caston. They're concerned that his addition could put more downward pressure on sentences. Why is he the best person at this time for the commission and when crime is very high?
Right, so the question has to do with the my nominee for the Sentencing Commission. The first, let me answer that by talking about the Sentencing Commission and then the actual process with regard to criminal prosecutions. The Sentencing Commission is overrated in terms of its role in the criminal justice system. The Sentencing Commission was created roughly 20 years ago, 25 years ago, because there was concern that there was vast inconsistency in sentencing in criminal cases, that 2 defendants who were similar in terms of criminal history and offense were getting widely disparate sentences. And there was a view that there ought to be more consistency, and that's what the guidelines are. The guidelines are a range. And when the Sentencing Commission adopted the guidelines, and the guidelines in place today have been in place for about 2 decades. So it's nothing new. Anybody who suggests that what's happening with crime today is a result of these guidelines, well, if that's the case, then it was the reason why crime was down so low 10 years ago. But what the Sentencing Commission does is it looks at what the offenses are, and excuse me, what the sentences are, and looking at all those sentences gets a sense of what the medium is and then has a range around that. Judges are free to depart or diverge from the guidelines, and they do sometimes. And the Sentencing Commission, when it looks at the consistency of sentences with the guidelines, this is not about judges adhering to the guidelines. It's really about whether the guidelines reflect what judicial practice is. And that's widely misunderstood. What really makes a difference in terms of sentences is what the law prescribes. So when the law says that possession is a maximum of 5 years, then the guidelines are going to be reflecting that. And when the law says that the maximum is 30 years, the guidelines are going to have a different range, sentencing range. So this is not so, this is not, if folks are concerned about sentencing, then the Sentencing Commission isn't where they should be concerned. I will add this, well, no, I'll wait for a moment. So the second point I want to say in response is that looking at the U.S. Attorney's letter, there is a complaint about how few sentences last year were a significant sentence. To be more specific, he cited, I think it was 4 different types of crimes that occurred, and said that, if I remember correctly, the total of the crimes that he cited, well, I'll just, what he wrote was in 2022, there were 203 homicides, 158 sexual abuse offenses, 485 carjackings, 1,387 assaults with a dangerous weapon, 2,082 robberies. And he complains that of that total, only 50 people received a sentence of 10 or more years. And I agree that that's a shocking number. Of course, that those sentences probably are for years predating, but in any event, 10 out of 4,315, 50 out of 4,315 is a shocking number. But what he left out of that was the fact that the case closure rate, that is the number of crimes, the number of 4,315 crimes that actually were closed with an arrest, was roughly 33%. Yes, about 33%. And then of the cases that were closed with an arrest, we don't have good data on papering decisions. We know that overall felonies, less than half of felonies were papered, but that's all felonies. But of the cases that were papered, 96.8% were plea bargained. 98.6% were sentenced based on an agreement negotiated between the U.S. Attorney's Office and the defendant. So when the U.S. Attorney complains that too few cases result in a lengthy sentence, that's his own doing. So I asked my staff to look at a few cases. Now, this is just a few cases, and I believe this was available through the Sentencing Commission website? No, through CJCC, through the website, through the web. Duran Hudson assaulted and murdered a homeless man, got into an argument with the homeless man, assaulted the homeless man by throwing bricks at him, and that wasn't good enough. So he got in his car and drove over the man, killing him. Ran over him. The initial charge, the arrest, was for involuntary manslaughter, which carries a maximum sentence of 30 years. This guy threw bricks at the homeless man and then drove over him, killed him. And the top charge was 30 years. The U.S. Attorney's Office offered a plea deal with a sentence of 8.5 years incarceration. Nathaniel Bates shot a man 6 times during an alleged robbery. This homicide occurred while he was on pretrial release for another case in which he had been arrested for possession of a firearm. The initial top charge was murder 1 while armed, with a maximum penalty of life in prison. He was also charged with 6 other offenses, including felony murder while armed and possession of a firearm during a crime of violence. The judge was uncomfortable with the plea deal, but ultimately accepted it since both the prosecution and defense had agreed to it, and the plea deal was a sentence of 7 years incarceration. Now, there's a whole lot more behind these cases. And I just sent a memo to members in which I said, in part, instead of finger pointing, that is, in this case, the U.S. Attorney blaming the Sentencing Commission for only 50 convictions resulting in a sentence of 10 years or more, instead of finger pointing, Let's look at the data and ask these questions. How do we increase the case closure rate? Why aren't the police closing more cases? And it's not necessarily they're doing something wrong, but what could they be doing to increase the closure rate? Why were less than half of the felony arrests papered? What's going on there? Is the U.S. Attorney saying there's poor police work, or the U.S. Attorney is, for some reason, just doesn't want to paper more cases? How do we increase this number? Why are the plea bargains more lenient than we would like? So what was the reason for Duron Hudson getting 8.5 years for driving over, throwing bricks at a homeless man and then running him over and killing him? Why was it only 7 years of incarceration for Nathaniel Bates, who shot somebody 6 times while on release with a gun charge? The answers are not easy, and I'm not saying that the U.S. Attorney did something wrong in these plea deals. I am saying that don't criticize that there are too few 10+ year convictions or sentences when you are the one who's negotiating these plea deals 97% of the time. So there needs to be, these questions need to be answered. And the third part of your question. So the Sentencing Commission, we have one appointment out of 17. There are 12 voting members plus 5 non-voting members. Virtually all of its work is done by consensus. The voting membership includes 3 judges, 2 prosecutors, 2 former prosecutors, and the director of CSOSA, works with returning, basically folks who are on probation or parole. The non-voting members who fully participate are MPD, Department of Corrections, the Federal Bureau of Prisons, the U.S. Parole Commission, and Councilmember Pinto. So this would be 1 member out of 17. The commission asked that we appoint a returning citizen. And in fact, this is consistent with what appears to be considered best practice and an emerging trend in other states. So we're seeing increasingly that other states are adding a returning citizen to their sentencing commission. Remember, the Sentencing Commission has guidelines for the purpose of consistency. It doesn't actually set the sentences. And in fact, our guidelines are a bit different than in most other states with sentencing guidelines, in that for all of our offenses, incarceration is a possibility. In many states, the sentencing guidelines preclude or have a presumption that incarceration is not appropriate. And then about the individual, he's well regarded. He committed a horrible crime in 1994, murdered somebody, lied about it subsequently. But the court, in a case involving a request for early release, noted that his behavior had been exemplary. I'm looking at some language here from a court decision. The court acknowledges the enormous strides defendant has made, both by finally accepting responsibility for his actions in the murder that led to his lengthy incarceration, and by his actions he has taken to improve himself while in prison through education, vocational programming, and in particular through mentoring other young inmates and co-founding the YME. ANC commissioner for several years and well regarded.
Question, the SNAP litigation resolution is still on the agenda. Why is it still being pushed forward?
It's on the agenda as a protective measure in case things don't work out, but the mayor last week indicated that she was going to proceed with administering the higher benefits. So it gives authority to the general counsel, which presumably will not be acted on. Any other questions? I want to thank everyone. The committee of the whole is scheduled to start at 11 and the legislative meeting will start after that. Thank you again.